and appeal in the matter of Kaur and others and the Secretary of State for the Home Office.
My ladies, my lord, I appear on behalf of the appellant, with my learned friend Mr. Rahman. My learned friend Mr. Ashosri appears on behalf of the respondent.
Yes.
There is an application as well as the appeal. The application seeks to dispose of the appeal without going into the merits. I don't know if my ladies and my lord have a view as to whether you would like to hear the application first.
Well, if you wish to pursue the application, obviously we'll hear it, but I have to say that our feeling is that we're all here, we've read everything, everyone's put a lot of work into the skeleton arguments and the supplementary skeleton arguments, so you're going to have to work quite hard to...
I don't remake the application.
I'm grateful, thank you. Well,
I'm grateful. Can I just check that the court has all the relevant bundles? There is a core bundle. There is also a supplementary bundle.
yes.
That was sent through, I think, the day before yesterday. That contains the application and some further documents that might be of assistance during the hearing. There is also an authorities bundle and 3 sets of skeleton arguments. There's the initial skeleton argument that the appellant advanced when seeking permission to appeal. There is the respondent skeleton argument and a supplementary skeleton argument on behalf of the appellant, which essentially responds to the respondent skeleton. Does the court have all of those documents?
We do. Yes.
I'm
Yes.
grateful.
Yes, and we've all had an opportunity of reading extensively into
Yes.
the papers
Yes.
and dipped into the relevant authorities,
Yes.
so you can take all that as...
I'm grateful, my lady. And we did get an email yesterday in relation to 2 further cases and statutory materials that the court wanted a hard copy of. I think my learned friend has 3 hard copies of those materials.
That's kind, thank you very much.
So, my ladies, my lord, the appeal concerns the interpretation of skilled worker, appendix skilled worker 2.2b, primarily, but there is also, in relation to that interpretation, an issue as to the proper scope and interpretation of paragraph 39E, because on the face of it, the 2 provisions seem to be inconsistent and working at odds with each other in the particular circumstances of this case.
Well, I'm sorry, but I'm not sure I understand that submission, Mr. Jafferty. No doubt you're going to explain it in more detail. But if one takes the decision in this case, the appellant had overstayed for a short period between the refusal of her last application and the making of the second application. If one looks at the decision, the Secretary of State did not treat that as a reason for refusing the application. So in other words, the Secretary of State appears to have applied paragraph 39E to the application and refused it on the basis that the appellant was on immigration bail. So I just don't understand how the 2 provisions are said to be inconsistent with one another.
Well, my lady, if it is right that the Secretary of State can and will place any person that becomes an overstayer on immigration bail promptly upon the person becoming an overstayer.
We don't know what the Secretary of State's practice is. We're just dealing with the facts of this case. On the facts of this case, that is what the Secretary of State did. Had the appellant not been on immigration bail when she made the application would not have been refused. I'm still not understanding what's wrong with that.
Well, my lady, we don't have any explanation as to why this particular appellant was placed on immigration bail. The tenure of the respondent skeleton argument, certainly I read that as the Secretary of State stating, well, in any circumstances where a person becomes an overstayer, that person is liable to immigration bail, and without more, there is nothing wrong with the Secretary of State placing that person on immigration bail.
Yeah. What's
and
wrong
if-
with that?
Well, there's nothing wrong with that in that the appellant is not saying that there's no power to do that. But what the Secretary of State must take into account is that the immigration rules, and a key part of the immigration rules and a key part of the Secretary of State's immigration policy, provides for an appellant to be able to make a further application within 14 days of becoming an overstay. And so if the Secretary of State is placing a person on immigration bail, that undermines that key part of the Secretary of State's own immigration policy.
Well,
there is
well,
no-
it would if it weren't for the presence of subparagraph B. But subparagraph B makes clear that whether or not you're an overstay when you make the application, if you are on immigration bail, it will be refused.
Yes, and if the court decides that there is nothing unlawful about that, the upshot of that will be that every applicant that makes an application whilst here lawfully and who is refused, whose application is refused, will likely, in my submission, be deprived of the opportunity that paragraph 39E positively seeks to provide such an applicant. And that might be the conclusion. It might
That
be
appears to be the intent.
are.
That appears to be the intention of the drafter of paragraph 2.2.
My lady, if that is what this court decides, then that is the consequence. But the consequence will be that the two provisions are working at odds with each other, because paragraph 39E clearly doesn't just give the opportunity to make a further application. It was placed in the immigration rules with the express intent of enabling an applicant to make a further application. And I've in the skeleton argument, we've put the four scenarios that will unfold where a person makes an in-time application or makes an out-of-time application but seeks to rely on paragraph 39E1. And what, in my submission, the court must grapple with is the likely circumstances that are going to apply when the Secretary of State decides whether or not to place somebody on immigration bail. And one has to go to the intent of the Secretary of State when bringing into force the exceptions for overstayer policy, which is a long-standing policy. I think it came into force in 2012. If I could perhaps take, my ladies and my lord, to the authorities bundle.
Certainly, thank you.
And we can look at 8C, I think it was 8C 195. Sorry, 8C 194, which is at tab 24,
Thank you.
page 579 of the bundle. This is the explanatory memorandum. And the court will see at 2.1, the sixth bullet point, explains the purpose of the introduction of the exceptions for overstayers provisions. And that is to introduce, first of all, a consistent approach to dealing with applications for leave to remain from migrants whose previous period of leave has expired. By enabling migrants whose previous period of leave has expired to qualify for leave to remain where the application is made within 28 days. And at that time, there was
28 before it was reduced to 14.
to 14, and there was also no requirement to show an exceptional reason why an in-time application wasn't made. 39E tightened up the operation of this policy, but the genesis of the policy is a desire to make it incentivize making applications quickly by those who become overstayers. And that is clearly an important part of the Secretary of State's immigration policy, because it means that those that become overstayers have an incentive to stay in touch, an incentive to sort out their immigration situation rather than becoming overstayers and then disappearing and making it more difficult for the Secretary of State to deal with them. For example, if somebody simply allows their leave to lapse, an incentive to make an application quickly after leave has lapsed means that the Secretary of State is in touch with them, knows what's happening, and can then deal with them in terms of enforcing immigration control. If there is no such incentive, of course, the person would simply disappear or incentivise to disappear, and then make an application further down the line. So that was the...
Well, but they won't disappear if they're on immigration bail.
My lady, if somebody just allows their leave to lapse, they then can simply, anybody can, to be fair, but what one has to set up a system whereby there is an incentive. One doesn't have to, but the Secretary of State's intent was to set up a system so that there is an incentive to stay in touch. That incentive means that more migrants are going to stay in touch, combined with the hostile environment, or compliant environment, whatever you want to call it. The incentivization is stay in touch, sort your situation out, because remaining without leave is going to become very difficult for you in terms of living in the UK because of the consequences, but also in terms of trying to regularize your status down the line. Of course, previously, prior to the 2012 provisions coming in, somebody could have overstayed for some time, then comes within the provisions of the immigration rules, makes an application, and that application can be granted. This changed everything. So the incentive was sort your situation out quickly, otherwise you will not be able to succeed under the immigration rules. And it is important to look at this because, and I'll take my ladies and my lord to the case of Afzal, which confirms that the policy in the 2012 Statement of Changes remains the same under paragraph 39E. There's no suggestion that there is a change in the overarching policy, but the way the policy is now applied is far stricter and has a certain set of rules that were not in place before, that shortens the period and also requires primarily an applicant to make an application whilst they still have leave, rather than treating both eventualities the same, whether you overstay your leave without making an in-time application, or you make an in-time application that is refused and then you make an application within the requisite period. If I could take the court to the bottom of page 581 as well, which is the specific section in the explanatory memorandum that deals with applications from overstayers. And one can see at 7.16, again, reference to ensuring that a consistent approach is taken. So the policy is, whatever your circumstances, you will be dealt with consistently in terms of your leave having expired. There is nothing that suggests that any category of applicant is going to be treated differently.
Well, that must be subject to specific provisions in the detailed appendices that deal with various types of application.
Well, my lady, at this time, when the policy was brought into force, there were no such provisions. So the predecessor to the skilled worker rules was the Tier 2 general system, and there was no such requirement that one must not be on immigration bail. 39E was the way in which one dealt with...
Obviously not, because immigration bail didn't exist in 2012.
I'm sorry, my lady?
Obviously not, because there was no such thing as immigration bail in 2012. It was introduced by the 2016 Act.
Yes, but of course there was temporary admission, other forms of control on a person's residence, and the Secretary of State's ability to keep applicants and migrants, keep in contact with them. And there was no provision that any of that would make any difference to the way in which the exceptions for overstayers was to be applied.
How does that help us with the interpretation of the current appendix with which we're concerned?
Well, my lady, one has to look at the rules in terms of what the Secretary of State intended. And if it is correct that the Secretary of State intended to amend the operation of paragraph 39E by the introduction of SW 2.2b, then the appellant would say it is very surprising that there is no explanation for that in the explanatory memorandum to the introduction of those provisions.
Well, hang on, I'm not following this at all. Why would there be an explanation in this explanatory memorandum which precedes the introduction of immigration bail and the provisions with which we're concerned?
No, not this one, the one that introduced SW 2.2b. So we'll come on to that. And what you will see from that explanatory memorandum is that there is nothing that explains why there is now an additional requirement that a person should not be on immigration bail.
Well, why does that matter?
Well, my lady, if one is trying to divine what the Secretary of State's intentions were, and it is submitted on behalf of the Secretary of State that the intention was to change the way 39E operates without changing 39E. And 39E is I would describe it as a flagship provision, overarching provision of the rules. One would expect some sort of explanation or some sort of policy guidance, some statement to that effect, because it is a drastic change in the way that 39E operates.
Right. If there is no such explanation, does that make subparagraph B unlawful in some way?
It doesn't make it unlawful if it is interpreted in a way that is consistent with the operation of the rules as a whole. So the task for the court is to ascertain what the Secretary of State intended. And that is done by looking at the operation of immigration policy and the rules as a whole.
No, with respect, that's not right. Surely the way that we divine what the Secretary of State's intention is by looking at the words of the provisions which we're construing.
My lady, that's the starting point, but one has to also look at the context within which those words were put in, and one has to look at how that operates in the context of the operation of the rules as a whole. If the way it operates means that one provision of the rules is rendered essentially nullified, that is something that the court in my submission must take into account when deciding how to interpret that provision. And I'll come on to the way that the court dealt with difficult provisions of the rules in Hock and in Afzal. The court has on many occasions expressed that the immigration rules are drafted in a very difficult way, and therefore it is not easy to simply read the text of the rule and apply it on occasion without modifying the obvious meaning of it, because the obvious meaning would seem to run entirely contrary to what the Secretary of State intended.
But I'm sorry, I'm just not following this argument at all. I've already suggested to you, and I think you accepted, that in a case where the applicant under this appendix is not on immigration bail, they can be an overstayer for up to 14 days and their application will be considered on its merits.
Yes.
Right. So the presence of subparagraph B does not nullify subparagraph A in that case.
No, not in that case.
So what your argument amounts to is that somehow the Secretary of State cannot make a more specific provision for those on immigration bail, the effect of which is to deprive them of 39E, whereas in fact it's not to deprive them of 39E, because 39E must have been applied here. It's to mean that there's another reason why they don't succeed.
My lady, the appellant's submission is not that the Secretary of State cannot do that. The appellant's submission is that the Secretary of State cannot have intended that. And therefore one has to read the rule in that way.
Sorry, can I just get a note of this? So the appellant does not submit that the Secretary of State could not have done that.
Cannot, doesn't have the power to do that.
Right.
The submission is that the Secretary of State cannot have intended that.
Right, and why? What clue in the language of the relevant paragraphs is there that the Secretary of State can't have intended that?
Well, my lady, if one is simply confining oneself to the paragraphs, that is, in my respectful submission, the wrong approach. One has to look at the history of the provision.
Sorry, let's just take this in stages. So if you can confine yourself to the paragraphs, that is their apparent effect, isn't it? Isn't that what you're accepting?
If one reads 2.2b at face value, that is clearly the effect of it, and that is what the Upper Tribunal found. At face value, that is clearly the effect of it.
Okay.
But if that is the effect of it, it entirely undermines the operation of 39E, and it undermines it in a way that means that 39E might well never bite, because the Secretary of State, the way the Secretary of State has presented her case, is that there is nothing special about this appellant that resulted in her being placed on immigration bail. The mere fact of her becoming an overstayer means that she could be placed on immigration bail. And so if I could take, my ladies and my lord, 239E itself.
Yes, just before we go there, can I just test the proposition you've just put to me? You said that if that's the effect, it entirely undermines 39E. Well, I'd suggest to you that it doesn't, because if the appellant is not on immigration bail, 39E applies.
My lady, of course, if the appellant is not on immigration bail, 39E would apply. But that doesn't mean that in practice it doesn't undermine it, because the Secretary of State is empowered, without anything other than the person becoming an overstayer, to lawfully place somebody on immigration bail without taking into account the impact on the 39E policy. And if that is the case, then every applicant that becomes an overstayer can be placed on immigration bail immediately, which means that the Secretary of State, without amending the rules and without changing her policy, can undermine that policy with an inconsistent approach to immigration bail, inconsistent with that policy, and simply take away the right of any person to make a further application. Now, if that is what the Secretary of State intended, one would have expected her to amend paragraph 39E.
Why?
Because why would, it seems, in my submission, my idea, it would be that it would be unreasonable and an odd way of drafting the rules to have a provision that gives and another provision that enables to take away without any explanation for that, without any reasoning.
But 39E doesn't apply in a vacuum. 39E only applies if and to the extent that it is brought into another rule. So, for example, if you look at paragraph 2.2,
yes,
paragraph 2.2 says something along the lines of, if paragraph 39E applies, then blah, blah, blah. So the Secretary of State in drafting the rules can decide whether or not to apply paragraph 39E to a particular provision.
And my lady, the policy of the rules is that 39E applies across the board. So
Well, shall we go? You were going to take us to 39E, so
Yes.
let's have that in front of us, shall we?
I'm grateful, my lady. Unfortunately, one of the key provisions doesn't appear to have been reproduced in the authorities bundle, but it's not in dispute. It is.
Exactly. That's
Yes,
where
and I was going to take my ladies and my lord to the case of Abzal at 157.
Tab number?
It's tab number 10.
It is in the authorities.
Apologies, it is in the authorities bundle. It's 577,
Right.
which is at tab 23.
Thank you.
Bottom of that page, one has the exceptions for overstayers provision.
Sorry, where am I looking?
The bottom of page 577.
Thank you. Thank you.
And one can see that the provision applies both where an applicant fails to make an application before the expiry of leave, but in those circumstances, the applicant has to show that there was a good reason beyond the control of the applicant or their representative why the application could not be made in time, or where the application was made following the refusal or rejection of a previous application for leave which was made in time, and within 14 days of, then you have the various provisions, but essentially within 14 days of the refusal, at which point, if there is no right of appeal or no right of administrative review, a person becomes an overstayer, or the expiry of the time limit for making an in-time application for administrative review or for appealing, or where Section 3C leave comes to an end. And the way that would work in practice in terms of the various scenarios that one might have, if I could take my ladies and my lord to the appellant supplementary skeleton argument.
Yes, thank you.
At paragraph 21, the appellant has set out the 4 scenarios where 39E would apply, potentially. So the first is, and this is where 39E1 bites, a person remains beyond the expiry of his permission to stay and then applies for permission to stay within 14 days. Of course, in those circumstances, it is a little bit more difficult because one has to show a good reason why the application was not made within time. But the likelihood is that in that scenario, the Secretary of State will not have granted immigration bail because the Secretary of State will not be aware that the person has become an overstayer. It is, in my submission, entirely impractical and respectfully fantasy to think that the Secretary of State will monitor a person's permission to stay and will grant immigration bail if no application is received from such a person at the time that their permission to stay expires. And of course, permission applications, further permission applications can be made electronically on the final day. So trying to monitor that and then place persons on immigration bail promptly is, in my submission, unworkable, impractical, and highly unlikely to happen. The Secretary of State doesn't suggest that that is her policy, that she's going to monitor and place all such persons on immigration bail promptly. And therefore, Category 1, the most culpable, if I could use that term, of persons seeking to rely on 39E, are the ones least likely to be disadvantaged because the Secretary of State has decided to place them on immigration bail. And one has to look at that in the context of the purpose of the policy and, of course, the express purpose of the policy to treat all these people consistently. The second one scenario is a person that makes an in-time application to extend permission, which is refused with no right of appeal and no right of administrative review. That is this case. And then applies for permission to stay within 14 days. This category of migrant is the most likely to be placed on immigration bail promptly because the Secretary of State will immediately be alert to the fact that Section 3C leave has now come to an end. There is no other time that one has to wait for before understanding when the applicant will become an overstayer. Category 3 is where there is a right of appeal or a right of administrative review after refusal of an in-time application. But the person does not exercise that right and instead applies for permission to stay within 14 days of the expiry of the time limit. It is, in my submission again, unlikely that the Secretary of State would monitor whether such an applicant had exercised the right of administrative review or the right of appeal. It might be that those who exercise a right of administrative review or fail to exercise a right of administrative review are much easier to monitor and are placed on immigration bail promptly or within 14 days of Section 3C leave coming to an end. But certainly those that exercise a right of appeal or fail to exercise a right of appeal, the Secretary of State is unlikely to monitor with the first-tier tribunal whether an appeal has been filed in time, and then if no appeal has been filed, to place them on immigration bail promptly. And the fourth category is a person that makes an in-time application for permission to stay, which is refused with a right of appeal or a right of administrative review, exercises that right, but eventually fails in the administrative review application or the appeal. This category, again, might be a category where the Secretary of State is effectively able to monitor and promptly places people on immigration bail once administrative review has been refused. That's easier. And once rights of appeal have been exhausted, that is a little bit more difficult because, again, one has to monitor whether a further application for permission to appeal has been made, and one has to monitor when an appeal draws to a close. There is no evidence before the court, but anecdotally, I don't think it is suggested by the Secretary of State that her policy is and her practice is to place all such persons promptly on immigration bail.
What category 2 persons are you talking about, or category 4 persons?
All categories, or category 2, any of the categories. There is nothing in the Secretary of State's policy guidance that suggests one must promptly place somebody on immigration bail.
Sorry, I may have misunderstood. I thought you were telling us that so far as little 2 was concerned of your 4 options, which applies in our case, that you would have expected such a person promptly to have been put on immigration bail.
No,
You were
apologies, my
saying
lady.
partly because they can be tracked.
What I was saying was that is the category which a Secretary of State is going to effectively be able to place on immigration very promptly.
You are the specialists. Is that not the routine outcome?
My lady, my experience, and again, that is why I said there is no evidence before the court. My experience is that this is a relatively new phenomena. It is not something that has found its way to the Upper Tribunal or to the Court of Appeal before this case, and there's one case at the Upper Tribunal which we have the papers for, SAFTA, where permission has been granted by the Upper Tribunal.
Sorry, I'm not being very clear. I'm not talking about when we, in the context of how it ties in, if it does, with 39E.
Yes.
I'm talking about just routine practice.
Yes.
I just got the feeling from you when you were explaining it.
That was the routine practice.
That was,
No.
There they are. They've made their entire application. They've no right to appeal, no right to administrative review, and so classic candidates for deportation.
Yes.
And therefore, as soon as that decision's made, they go on immigration bail.
My lady, not in my experience. That is something.
I understand the practice.
No, my submission was that is the category. If the Secretary of State did want to do that and was acting consistently across all migrants, then that is the category where one would expect that she would be able to consistently place persons on immigration bail. It might be that the Secretary of State's current practice is to consistently place such persons on immigration bail.
Certainly did in respect to this person.
Yes, and I know that there are other cases as well where that has happened, but historically that has not been my experience, certainly.
We've got to, things change, particularly in the world of immigration.
Yes.
So
absolutely, my lady, absolutely.
It's much more common than it used to be.
It's much more common than it used to be, and that is why the appellant submits that the court must grapple with the consequences of that, because if it is the case that category 2 is the easiest to monitor, and therefore the Secretary of State will likely, invariably place such migrants on immigration bail, there is now an inconsistent application of the 39E policy, which is contrary to the policy intent from 2012. There's nothing to suggest that the policy intent has changed, and in fact the Court of Appeal in Avzal suggested that it hadn't, and therefore, and we have no explanation for it. There is nothing in the policy guidance, there is nothing in the way that the Secretary of State presents her case that explains why she has decided, if she has decided, to amend her practice, conscious of the fact, and it might be that she was not conscious of the fact, but we say that if she was conscious of the fact, then that is unlawful, because it is irrational and unreasonable to act contrary to your own immigration policy.
Sorry, I'm so sorry, I just want to understand this. Are you suggesting that subparagraph 2b is unlawful?
No, I'm saying that where the Secretary of State decides to place a person on immigration bail, aware that by placing that person on immigration bail at that particular time, he or she will be deprived of the benefit of 39E, that is an unreasonable decision. And if no account was taken of it, then that is also an unreasonable decision for failing to take account of a relevant matter.
But I'm sorry, I'm not understanding this. If the Secretary of State is permitted to do that, and if that's the effect of subparagraph 2b, how is it unlawful?
Well, my lady, where the Secretary of State has options, which option she decides to take is a matter that is subject to challenge on ordinary public law principles. And I think in our initial skeleton, we cited the Upper Tribunal case of Mohibullah, where the then president said that where there are 2 options available to the Secretary of State in terms of how to act, which option he or she chooses is a matter that is subject to challenge on ordinary judicial review principle grounds.
But that would be a challenge to the decision to put this appellant on immigration bail.
Yes, and that is where the historic historical wrong issue comes in, whether that decision, albeit not challenged at the time, was actually unlawful.
Again, help me with this. I'm wearing my old plates on this particular topic. If someone has chosen not to challenge,
Yes.
when they had a right and an opportunity to do so, can they still argue historic injustice?
My lady, the way the appellant puts it, relying on case law, which I accept relates to the application of Article 8 and proportionality when one is assessing Article 8, but the same principle applies when one is assessing the reasonableness of a decision. If the Secretary of State decides that the only reason why this application should be refused is that the appellant was on immigration bail, then in my submission, if she fails to take account of the context within which the applicant was placed on immigration bail, then that is a public law error susceptible to challenge. The Secretary of State ought to have considered that at the time she was placed on immigration bail, she had just become an overstayer, and that's another issue that the appellant raises, whether she was actually an overstayer at the point of refusal or whether she became an overstayer on the day after. But let's assume that it was right to place her, there was a power at that time to place her on immigration bail. The Secretary of State always has a discretion in applying the immigration rules. And if the Secretary of State considers that 39E, the flagship provision with respect to treating consistently persons that become overstayers, was satisfied, she acted promptly and she did everything else appropriately. But she is deprived of this, the right to be granted permission to stay because she was placed on immigration bail by the Secretary of State. In my submission, it is arguable that the Secretary of State ought to have considered that it would be unfair and unlawful and unreasonable to refuse her solely on that ground, because by doing that, the Secretary of State took away the opportunity that the immigration rules positively gives to all such applicants, and the policy of the Secretary of State from 2012 onwards that such persons should be treated consistently. This is clearly inconsistent treatment and without any explanation, and that's the difficulty. One has, on the one hand, the long-standing policy that persons such as the appellant ought to be permitted to make a further application, and on the other hand, without explanation, a decision to take that opportunity away from her by placing her on immigration bail.
But the Secretary of State doesn't have a crystal ball. The Secretary of State did not know when she refused the application that the appellant was going to go on and make an application under this appendix.
That's right, but the Secretary of State did know that her own immigration policy gives every such applicant an opportunity to make such an application within 14 days. That is her policy. And it's not just an obscure policy. It's a policy that came in with some fanfare, was changed every time with explanation, and has its own policy guidance that clearly says 14 days is the period that an applicant ought to have to make a further application.
So are you saying that the Secretary of State would be acting unlawfully in making an order for immigration bail prior to 14 days?
Yes. That is essentially the appellant's submission, that to place a...
You're asking this court to find, you mean if we went on views?
Well,
Ask us to hear a judicial review.
yes.
Even though you didn't challenge immigration bail, I'm asking this court to find, as a matter of law, that any Secretary of State is acting illegally if they impose immigration bail on any person prior to the expiry of the 14 days?
Well, my lady, the first way in which the appellant puts her case is that in light of all of this, one must construe the rules so that...
I understand
Yes.
that, and helping me enormously
Yes.
going through this. But
Yeah.
I just want to be absolutely crystal clear what your ultimate case is, and
Yeah.
have I summarised that accurately?
Yes, if the immigration rules cannot be interpreted in that way, then the appellant would say, and of course we're focusing on this particular case, and so in this particular case, what we say is that in order for the Secretary of State to establish that placing the appellant on immigration bail at that time was lawful, she needs to establish that she gave consideration to the impact on the appellant's ability to make a further application, the impact on the operation of 39E, and decided for X, Y, and Z reason that she should still be placed on immigration bail. And that, of course, all in the context of the Secretary of State retaining the power to place her on immigration bail after 14 days.
So what, from a practical point of view, are you saying the Secretary of State has to do in every case where a refusal is made and potentially 39E might apply? The Secretary of State has to make inquiries as to whether they intend
Well, my lady,
any applications under the appendix.
my lady, it wouldn't have to work that way because, of course, there is only a very short period within which an applicant can make an application, 14 days. So the Secretary of State could
travel a long way in 14 days.
Yes, but placing them on immigration bail, of course, doesn't prevent them from doing that. It's simply the immigration. If we look at the immigration bail grant, my lady, if we go to the decision first, which is in the supplementary bundle.
Thank you.
It's at page 205. You can see on the covering page of the decision, the covering letter that accompanied the decision, it says there is no right of appeal, you must now leave the United Kingdom, and you are granted immigration bail from the date of this decision.
Yeah.
If we go towards the end of the decision at page 212, removal from the UK, you have the option to leave the UK voluntarily. And then, however, should you be removed, tells the applicant the likely transit points. And then it says at the bottom of that page, you will be given further notice of when you will be removed. And then if one goes to page 213, at the top of that page, immigration bail, you are granted immigration bail subject to the following conditions. One is you are not allowed to work, but of course there's no reason to impose that condition because in any event she's not allowed to work, having become an overstayer, and one would expect it to be difficult for her to find work, having become an overstayer. And then it simply informs the appellant, you must tell us if your contact details change, including your address, email address, and telephone numbers, but that doesn't require immigration bail. There is no reporting requirement. There is no residence requirement. And so the grant of immigration bail in my submission in this case does not do anything to prevent a person going a long way within 14 days. And if we go to the main bundle, at page 117,
Sorry, core bundle.
the core bundle, at page 117.
this the same decision as we've just looked at?
It's the grant of bail decision. So the
Oh, I
refusal.
see.
Yes, the refusal of application itself said bail has been granted, and then there's a separate notification, bail 201, which grants bail. The only condition is that she's not allowed to work. I think the documents that follow are not from the bail document. They seem to be pages from the immigration decision itself. So 118, 119, 120.
Yes, it seems as though it's been sort of stuck in the wrong,
Yes.
wrong part.
I think 121 is from the bail document,
Yes.
and then at 123 you have the grant of immigration bail to, I think it must be the husband, and that seems to be the proper full version of it, and you can see the full document there. And whilst we're on the immigration bail documents, if I could take the court to the immigration bail guidance in the authorities bundle, which is at tab 27. One can see from the table of contents that the bail policy is focused, as one would expect it to be, on cases where a person is in detention and being granted immigration bail.
So where are we reading from?
I'm just, my lady, looking at the table of contents at 597. The point is that when one looks at the table of contents, overall this policy is clearly focused on circumstances where a person is in detention, or circumstances where a person is encountered because they're an overstayer, a person subject to deportation, so they've come out of prison and they're now in immigration detention, or consideration is being given to granting them immigration bail, or where the first tier tribunal is dealing with an application for bail. I'll be corrected if I'm wrong by my learned friend, but there's nothing that I've been able to find in the policy guidance that deals with the circumstances of the appellant and all the other scenarios that one would expect when 39E comes into play. So somebody that has arrived in the UK lawfully, or at least for 39E, that is the appellant's case, but if we're looking generally at 39E, somebody that is present in the UK lawfully and is seeking to extend stay, either by having made an in-time application that was refused and then a further application, or somebody that doesn't make the application before permission expires, but does so promptly within 14 days.
Are they not protected or covered, I should say, by the policy that's set out in the introduction at page 603, setting out the policy that detention will only be used sparingly and as a last resort, presumption in favour of not detaining. So that doesn't quite fit with yours. This is all designed for people who are already detained.
What I meant was...
That covers exactly your case.
My lady, what I meant was that there is nothing in this guidance that tells a caseworker what to do in those circumstances in terms of granting or not granting bail. There's no policy, there's no guidance as to what considerations to take into account. There's nothing that tells them to consider that 39E applies and overstayers can make an application within 14 days and therefore that is something you should take into account, or that is irrelevant, or that in those circumstances, these are the types of cases where you might consider granting immigration bail, even though that would take that right away. So that scenario is not discussed, whereas all the other scenarios, as one would expect in policy guidance, the caseworkers are given detailed guidance, factors they should consider, the normal outcome, when to exercise discretion, when to seek authorization from senior caseworkers. But this scenario is simply not considered or provided for.
Can I just ask you a question, please?
Yes.
My understanding, and I may be wrong, which is why I'm asking you the question because you're the expert and I'm not, is that the effect of paragraph 39E is that it does not stop a person from being an overstayer. Its effect, rather, is that any period of overstaying up to 14 days is overlooked for the purposes of deciding whether or not the person is in breach of the immigration laws if they make an application within 14 days.
Yes.
So that's right, is it?
Yes, absolutely.
So they are an overstayer.
Yes, they are overstayers.
Thank
Can
you.
I just ask this? This is going to be probably a stupid question, but in the what seems to be the exceptional case, where someone who's liable to detention is detained, how does paragraph 2.2 of the skilled worker appendix operate?
That is, my lord, a point that I was going to make, that you have the perverse situation whereby somebody that the Secretary of State decides is not suitable for bail, but is placed in detention, is in a more advantageous position because 2.2b does not apply. And therefore, for instance, and this is something that I wanted to come on to as well, the Secretary of State can cancel permission with immediate effect in suitable circumstances. And the one that one often sees at the moment is a person that is found working in breach of conditions of permission to stay, somebody that hasn't started their course, is here for the purposes of study. Often intelligence-led operations or chance encounters will result in immigration officers taking the decision on the spot to cancel permission with immediate effect. That means that permission is cancelled at that point in time. And what one usually sees in those circumstances is that the Secretary of State will not place that person on immigration bail because the fact of the breach renders them a person that is considered not reliable and therefore not likely to comply with conditions of immigration bail. They will be placed in detention. SW 2.2 in those circumstances would permit such a person to make an application within 14 days and not to be refused on the grounds of 2.2b because they are not on immigration bail, they are in detention. The only reason that such an application might be refused is on general grounds, but 2.2b would not bite. And of course, if a person such as the appellant has something in her history that the Secretary of State considers ought not to result in her being granted leave under skilled worker provisions, the Secretary of State always has recourse to general grounds. As 2.1, I don't think it's 2.1, I think it's the introduction to 2, itself says, if I could take, ladies and my lord, to that provision, it's at tab 22. Page 506. And so 2.1 provides the Secretary of State all the powers within the rules to refuse an application because the Secretary of State simply considers that that person ought not to benefit from a grant of permission to stay under skilled worker route. So
doesn't in breach of immigration laws, if you're working when you shouldn't have been working and so get detained, wouldn't they be in A?
yes, if that is the case. So if a person has...
Is it really the case that someone detained is, maybe theoretically, but isn't the reality that if they're detained, they're going to be caught by A?
My lady, I would say no, because although the Secretary of State has determined that that person is in breach of immigration laws, it might well be that the person establishes later that that was wrong. and they were not in breach of immigration laws. And therefore, the fact of detention having become an overstayer will not be something that prevents the grant of an application, but if that person had been released on bail, that would. So one has to then rely on the breach of immigration laws. And if there's been no breach of immigration laws, and the Secretary of State got it wrong for whatever reason, and that does happen, we have lots of judicial reviews that are settled and succeed because the Secretary of State has misunderstood or misinterpreted the evidence or
Yes,
their
but
explanation.
that's ex post facto. At the time, if such an application is made and the Secretary of State reasonably considers that the person is in breach of the immigration laws, my lady's right. The Secretary of State can refuse the application under 2.2a.
Yes, and that person can challenge.
I think that's the point that I was getting at.
Yes, no, but when one follows that through, the challenge, and if under challenge the applicant establishes that actually there was no wrongdoing, 2.2b would not bite.
No.
But anyway, you say that there is potential. That we'll
Yes.
think about that submission in the context of A.
Yes, and the appellant, of course, somebody that has not been accused of any wrongdoing, is refused and cannot challenge that because she is on bail, unless, of course, it is the case that placing her on immigration bail was not lawful. So a person that's accused of wrongdoing can clear their name. A person who hasn't been accused of wrongdoing but is placed on immigration bail has nowhere to go with it, unless it is the case that the Secretary of State ought not to have done that.
Thank you.
If I could again go back to the bail guidance, which we were looking at.
Certainly tab 27.
Yes, and it's page 604. Apologies, 605.
Thank you.
I think that might not be the right place. Apologies, I'll just. I'm sorry, my name's Mel.
Right,
It's
take your
603. 603.
603.
It's in the introduction.
Thank you.
And it's the last paragraph in the section introduction, just above transitional provisions. And this is, of course, this isn't a submission that this paragraph circumvents or restricts the Secretary of State's power. It's the Secretary of State's policy and the way in which she exercises the power. And one can see very clearly stated that the purpose of immigration bail, as far as the Secretary of State is concerned, and the way that she will exercise the power, is aligned to the purpose of detention, which is to facilitate the return of individuals who have no legal basis to remain in the UK. And of course, it is a power, it's not mandatory. There is nothing that requires the Secretary of State to place anybody on immigration bail. And one can see from the Secretary of State's policies with respect to removal, if I take you to tab 28. There is, if we go to page 713 onwards, detailed provision made by the Secretary of State in her own policy guidance about the steps to take when deciding whether to pursue enforcement of removal. 714, assess and gather available information. And one of the things that you will see throughout this guidance is checking whether there is anything outstanding. So if one looks at page 714, the third paragraph above the subheading previous appeal, judicial review and application outcomes. In addition, you must also check that there are no outstanding submissions. One has to look at family welfare and family separation assessments, making a request for further information and evidence at 716. The point is that the process of removal, we have step 2 at 721 and it goes on, but without going into too much detail in terms of the detailed provisions of the guidance, the Secretary of State has herself made detailed provision for the process of deciding whether to enforce removal.
Step 1 that you... Sorry, I keep asking questions I probably ought to know the answers to. Step 1 that you just took us
Yes.
to. You're saying this is for the process of removal, but it says undertake an assessment as to whether the person is liable for removal. But your lay client was liable to removal. So does this apply? Because that's already known.
Well, my lady, it is known, but it is known at the point of refusal. I accept that. But the process requires much more than establishing that a person is liable for removal.
So it's just that step 1, you're relying on gathering information, and I'm just asking the question that my reading of the first paragraph of step 1 doesn't seem to apply in our case, because already liability for removal has been established. So this step 1 doesn't apply in our case, does it?
My lady,
or does it?
Step 1 does apply. It might be that step 1 is satisfied, but when one looks at step 1, it's assessing and gathering available information, because one needs that for steps 2 and 3.
Understood.
And the point is that before one enforces removal, of course, enforcement of removal is a last resort.
Understood.
The Secretary of State expects people to depart voluntarily. That is what the refusal, like all refusals, says. And enforcing removal is expensive. And so the Secretary of State would obviously expect and prefer that people leave voluntarily. The process of enforcing removal can itself become drawn out and expensive, because if you take that step too early, and in fact the applicant has other bases for remaining which have not yet been considered, again, that is wasting resources, wasting time and money on a process that is inevitably going to falter. And so this guidance provides a host of actions, information that must be gathered before one takes the step of deciding that enforcement of removal is appropriate. One would expect that in a case where we have a family that has arrived here lawfully, there is an issue potentially with a passport being available for the minor child. That is something the Secretary of State was aware of, because that was the basis of the application, one of the bases of the application that was made in time, that 6 months leave was required because the child has just been born and there's no passport, so they cannot practically leave the UK. One would expect that the Secretary of State would not take steps to enforce removal at the point where the in-time application has just been refused.
Thank you.
And as part of that process, in my submission, one would expect the Secretary of State to also consider the provision in the immigration rules that mean that within 14 days, this person might make a further application. And therefore, before deciding whether I'm going to take steps to enforce removal, I ought to wait and see whether that is going to happen. That, of course, and we have a complete absence of reasons here in terms of why it was decided to place the person, the appellant, on immigration bail immediately. But these steps have not been followed. And again, one has the administrative removal notification implementation guidance at 868 tab 32. I won't take my ladies and my lord through it in any detail, but one can see from the guidance that there are detailed steps that must be followed in order to enforce removal. And if the Secretary of State's own policy is that bail is a tool that is to be used in order to enforce removal, that is allied to the power of detention, which is in order to enforce removal, then it is, in my submission, surprising that it is exercised, that power is exercised at the point a hitherto lawfully resident migrant becomes an overstayer, particularly where by doing that, there is an express, an obvious disadvantage to that applicant, and the Secretary of State has given no reasons for deciding to take steps that would undermine the migrant's ability to rely on 39E and make a further application.
Would you accept that there's a distinction, Mr. Jaffergy, between liability to removal and enforcement of removal?
Yes.
Thank you.
If I could take the court to tab 20. This is the guidance that relates to paragraph 39E.
Sorry, tab 20.
Tab 20, page 766
In the
of the authorities bundle.
Tab 20 in it is page 403, which is an authority. An
Apologies, it's 29.
That's all right, thank you.
That's 768, under the subheading about this guidance. One can see that the guidance covers all work and study, including the points-based system route, so it covers the application made by the appellant. And at 770, you have the section of the guidance that gives the history of the provision, the initial 28-day grace period, followed by the reduced period of 14 days. Five paragraphs in, clearly says second overstaying will be disregarded where the applicant previously made an in-time application which was refused. That applies to the appellant's circumstances. On the following page, calculating the date the period of overstaying begins. That is important. One starts the calculation after the last day of the migrant's leave, and that is related to the appellant's submission that she was not an overstayer at the point that immigration bail powers were exercised. That was in fact the last day of her leave.
Again, not challenged at the time.
No, not challenged at the time, really. And then at the bottom of 772, status following submission of an application within 14 days of overstaying. One can see that in the second subparagraph, it goes without saying that there is no permission to work. One doesn't need a grant of immigration bail to enforce that. And one can see the consequences for an employer. And then at 773 to 774, you have examples the policy which applies to the route that the appellant applied under clearly is based upon any migrant who has come to the end of their leave having a period of 14 days within which they can apply, and that application would not be refused on the basis that they are an overstayer.
But the application wasn't refused on the basis that she was an overstay.
Not directly, my lady, but in essence, the grant of immigration bail was because she was an overstayer. That is the basis upon which the bail was granted.
Sorry, it seems to me you might be confusing two different things, but anyway.
My lady, that is the submission. When the grant of immigration bail, that power arises because of overstaying. It's not directly refused on the basis of overstaying, but in my submission, one cannot get away from the fact that it is the fact of overstaying that has led to the ground of refusal, because that fact of overstaying has led to the grant of immigration bail. If one then goes to the next tab...
No, what leads to the grant of immigration bail is the refusal of the application and the fact that she's got no further right to stay in the United Kingdom.
Which means she's an overstayer. And it's the operation of Section 10 of the 99 Act. If you require leave but you don't have it.
I think what the lady's saying is going back to your 4 categories,
Yes.
you can be an overstayer but still have rights of appeal.
You wouldn't be an overstayer at that point, my lady. If you have a right of appeal, your overstaying begins at the end of the appeals process. So Section 3C leave would continue whilst you have the right to administrative review and you've exercised it. It would also continue whilst you exercise, whilst you have the time limit within which to appeal and whilst the appeal is pending.
I thought it was you remain an overstayer throughout, just that those periods are disregarded.
My lord, if you make an in-time application and the application is refused, but it comes with a right of appeal or a right to administrative review, whilst that time limit is pending, your Section 3C leave continues. And it is only at the point where those rights are either not exercised or exhausted that you become an overstayer.
This is Section 3C.
Yeah, but we're not concerned with the Section 3C leave case here. At the point when the appellant's application was refused, she didn't have a right of appeal.
No, and that's the point at which her Section 3C leave comes to an end.
Yes, exactly.
Yes.
Yeah. So sorry, I think you, my lady, might slightly been at cross purposes because I don't think she was really interested in exploring. Anyway,
It's all knowledge.
And if I could then take the court to page 787.
Thank you. 787.
This is the skilled worker guidance. And this is the only explanation that we've been able to find in relation to the reasons for the immigration bail requirement. It simply says any applicant who is in the UK on immigration bail is not suitable for the skilled worker route. These individuals do not hold permission to be in the UK. Now, of course, that explanation applies to anyone that falls within 39E. And there is nothing further in the policy guidance that explains why being on immigration bail within the first 14 days of becoming an overstayer would render a person unsuitable for a grant of further permission to stay.
but it doesn't matter because that's what subparagraph 2B provides.
Well, my lady, the appellant's submission is, as I have said in written submissions, and it might be the court doesn't accept it, but the submission is that one has to interpret the rule in the context of the overall operation of the rule, the overarching policy imperative pursued by paragraph 39E, which is a provision that dates back to its predecessor provisions from 2012, where the intent was to treat all applicants who would become overstayers consistently, fairly and proportionately. And one has to confront the fact that applying literally 2.2b to the appellant's application results in taking away from her the right expressly granted by paragraph 39E, and that is an inconsistent outcome. And as Lord Justice Nuggie said in granting permission, the proposition by the Secretary of State is logical. The appellant becomes an overstayer. There is a power to grant immigration bail. That power is exercised. There is, on the face of it, nothing exceptional about that. The appellant doesn't say that there is any infringement of her liberty by the exercise of that power, or that that power could not have been reasonably and rationally applied 14 days later. What she says is that it was unreasonable. Well, either it's perfectly proper to do that, but one must interpret SW 2.2b so that the outcome is consistent with the immigration policy pursued by paragraph 39E, which is a long-standing policy with a lot of explanation, both in policy guidance, both in the explanatory memoranda, which introduce various versions of the policy, and which expressly states the intention is that this policy should operate consistently. So on the one hand, you have that policy imperative. On the other hand, you have no explanation why immigration bail should be a reason for refusing a person in the appellant's circumstances. And you have the explanation in the policy guidance that the reason why you should refuse in these circumstances is because she's an overstayer. But of course, that runs entirely counter to the 39E policy. So one does have an inconsistency in my submission. There is a conflict when one gets into the purpose and the history of the rules and the way that the Secretary of State has been operating the rules.
Well, I understand all of that, Mr. Jafferty, but how are you saying that the language of paragraph 22b should be interpreted?
That it cannot be. I'm not sure. I think we put forward an answer. We should have.
I don't think you've got the words. I mean, you don't always have to provide us with the words in this context.
I mean, what are the words that we have to substitute for the words that have been used by the Secretary of State and approved by Parliament in paragraph 22b?
If my lady would just bear with me, I'm sure we said something about this in the supplementary skeleton. My lady, it's paragraph 26 of the supplementary skeleton. And in essence, what the appellant is saying is that that provision must be applied where it doesn't conflict with 2.2a. And that is the only sensible and rational way of reading it.
You need to insert some words like in any other case or something like that.
Yes.
And where paragraph 39e does not apply.
Yes.
Right.
And my lady will see from the decisions in Hock and Abzal that the court has gone much further than that to make sense of the rules. In Hock, it was essentially a complete restructuring and writing of the rule because the rule did not otherwise make sense. And so this isn't something exceptional. It isn't exceptional that the immigration rules don't, on the face of it, make sense. It's something that the court has remarked upon on a number of occasions. And I will, if I may, take the court to some of those comments. Maybe now is the right time. If I could take the court to Hock and others, which is at tab 11, page 175. At 176. In the head note per curiam, the court has frequently in recent years had to deal with appeals arising out of difficulties on understanding the immigration rules.
The provisions which this court was considering in Hock were more complicated and labyrinthine than the provisions we're considering, which are, on the face of it, quite simple and clear.
Yes, but as I say, the appellant says there is still an inconsistency. There are two policy imperatives that seem to be clashing, and one has to make sense of that.
Well, one way of making sense of this is to say that what the draftsman has done is to show how those two policies are to be reconciled, and that is by providing that even where 39E applies, you're refused if you're on immigration bail.
My lady, that is what the court might well conclude. But the upshot of that will be, of course, that it might well be that 39E has no relevance or application at all anymore, because the Secretary of State can place...
That's clearly not right, because you've already given at least 3 examples of types of case in which 39E will have effect, because for one reason or another, the Secretary of State won't be monitoring these people, and they will be able to apply.
And if that is the case, then it sort of results in an outcome that is contrary to the 39E policy. The very person that is complying is the one that is most at risk of being deprived of the 39E policy. And category 1, who simply overstays, is in the best position in terms of being able to take the benefit of 39E. And it also results...
They're in breach of the immigration rules, so they're stuck as well.
I'm sorry, my lady?
But they're in breach of the immigration rules.
No, my lady, because the 39E provides for that to be disregarded. So 39E, 39E1
yes, beg your pardon.
permits, my lady. So that person, hypothetical person, who has simply failed to make an in-time application...
Any person that has not been made subject to immigration bail in any one of your 4 categories will not...
will not. And then that begs the question, well, what was the reason for placing the appellant on immigration bail? We don't have a reason. There's never been any explanation for that. There are no notes in the GCID notes that explain why a decision was made. And then that, of course, undermines the clear policy imperative when this whole overarching policy for overstayers was began in 2012, that the reason for introducing this was to introduce a consistent approach. And what we now have is inconsistency without any explanation. So we don't even know why there is inconsistency. And if it is the case that you have a category that is deprived of the benefit of 39E because of the way in which the Secretary of State practices the exercise of powers to grant immigration bail, there at least ought to be an explanation for it, a reason.
Is this an explanation, a possible explanation? Assume a lawful and rational decision to grant immigration bail. The person who is in that situation is unsuitable for the grant of leave under the skilled worker route, which is all we're concerned with. And that the 39E disregard is disapplied. That other people in your other categories might fall for refusal, as you've pointed out, on the general grounds, and the overstayer who doesn't bother to make an application before leave expires might be such a person. So at least we've got a clear rule that a lawful decision to grant immigration bail is a disqualifying factor. It just takes you outside 39E. That's the effect of it, and there's perhaps a hint of the rationale, unsuitability on that ground in the guidance.
My lord, the appellant would say that simply would not work. It would only work if, in the appellant's case, there was some explanation. There was some reason why it was decided that this appellant was not suitable to be granted permission to stay on the skilled worker route, despite being here lawfully, making an in-time application, making another application within 14 days, no other adverse conduct, no criminal conduct, no illegal entry, no period of overstaying in the past at all. Why is this appellant unsuitable? Except because she's an overstay. That's the only reason. If there was another
No,
reason.
it's not because she's an overstayer, it's because she's on immigration bail.
But my lady, that flows from being an overstayer. There's no other reason for placing her on
Yes,
immigration
but you
bail.
might be an overstay and not be subject to immigration bail. I mean, we keep circling back to the same point.
And there we have the inconsistency. The inconsistency which is unexplained.
It doesn't need to be explained. That's the rule that the Secretary of State has put before Parliament and which Parliament hasn't disapproved, and we're stuck with it. It's not for the court to say this is inconsistent, we can redraft it, is it?
It is for the court to divine what the Secretary of State intended. And in my submission, it cannot be that the Secretary of State intended that there would be inconsistent application of 39E when 39E does not, in its text, envisage any such inconsistent application. And when 39E was introduced and when its predecessor provision was introduced, the policy was to introduce consistency. That's the submission.
We have your point on that now. So where do we go next?
There is one other thing that I ought to say. If the court is looking for a reason why there is a provision that requires a person not to be on immigration bail that is consistent with the operation of 39E, that is, in my submission, the situation of persons that are here lawfully but subject to deportation proceedings. Because such a person, upon completion of a prison sentence, so if it's 12 months or more, there's automatic deportation provisions that would apply. Such a person might well eventually, perhaps immediately upon the expiry of their prison sentence or sometime thereafter, be granted immigration bail in circumstances where the decision to deport has not yet been made. And therefore, although they are liable to detention and liable to be placed on immigration bail for that reason, because they are subject to deportation proceedings, they are not here unlawfully until the deportation order is made. And such a person would fall foul of 2.2b whilst not falling foul of 2.2a. So it isn't that the appellant says that there is absolutely no reason for 2.2b. That is the only category that the appellant has been able to identify where, notwithstanding the person meets 2.2a, 2.2b would still apply. Of course, it might well be that the Secretary of State could simply put such an application on hold. It might also be that the Secretary of State could decide to refuse the application forthwith on general grounds of refusal. But 2.2b would also apply if the person was on immigration bail without needing to have recourse to general grounds of refusal or without needing to put the application on hold. Apart from that, it is difficult to see how 2.2b adds anything to 2.2a. And when one looks at the policy guidance with respect to skilled worker applications, there is nothing there, nothing in the explanatory memoranda that explains why that provision adds something to what was already there. And this, it might well be that this was the intention, to ensure that persons who are subject to deportation proceedings are not able to make applications that might on the face of it succeed.
Is it remotely likely that someone who's subject to deportation proceedings is going to apply for leave to remain under this route?
My lady, one simply doesn't know, but the rules are drafted to ensure that every eventuality is catered for, and it might well be that somebody who's subject to a relatively short period of imprisonment then decides to seek permission to stay on that basis. It might be that person's leave is coming to an end.
Unless they're a habitual offender, they won't be liable to deportation unless they'd be sentenced to at least 12 months imprisonment.
Yes, or habitual offender, or any circumstance that leads to deportation. It might be that that person's permission is on the skilled worker route. It might be that that is the route that they were on when they when they committed the offence, and it might be that they seek to extend
I imagine
it.
being sent to prison would be a breach of your conditions, but anyway.
But my lady, there are all sorts of reasons. I mean, general grounds of refusal always apply, but we still have this provision, and that is the way the provision would operate in these circumstances. If one is looking for a reason for its existence and when it would bite, if it doesn't bite when the appellant says it ought not to bind.
Anything else?
My lady, I just wanted to take you. You have the per curiam head note from Hock. I'll just give you the reference numbers for the paragraphs in the judgment that make reference to that. It's paragraph 96,
Yep.
Paragraph 105. And if I could take also the court to Afzal, which has been referred to also in the skeleton. One has, this is at page 162, it's the case just before Hock. That's paragraph 11, subparagraph 8, which is on page 162, and then paragraph 12, which follows. That is in relation to the point of time at which a person becomes an overseer, and the appellant says that she did not become an overseer until the day after she was served with her notice. That would be consistent with the timeline and the Secretary of State's position on that. If I take you to the helpful background in my learned friend's skeleton argument at paragraph 8. You will see that the in-time application was refused on the 28th of April. And that the further application, which it is accepted, falls within 39E2, was made on the 12th of May. So it must be that the overstaying began on the 29th of April. Because if it began on the 28th of April, that would be 15 days after she became an overstay. And if I could then take you back to Afzal at 167. Paragraph 45. In construing 39E and the long residence provisions, the court had, like it did in Hock, regard to the explanatory memoranda, the history of the provisions, and in particular, regard to the policy which is quoted to introduce a consistent approach to dealing with applications for leave to remain from migrants whose previous period of leave has expired. And at paragraph 47, the first sentence, the court stating that there was no indication that the basic policy introduced in 2012 was intended to change. And at paragraph 50, consistent with what is said earlier in Afzal in terms of the ultimate exercise when construing the rules, at paragraph 50, the last part of the last sentence reflects the intention of the Secretary of State in adopting the paragraph. And the appellant's submission is that that is really what the task for the court is.
But sorry, Patrick Elias's judgment. What Patrick Elias is saying there is that the language of paragraph 39 was potentially ambiguous, and that any ambiguity utterly dissolved in the light of its obvious purpose. At the moment, are you submitting that paragraph 2.2 is ambiguous?
The operation of it is
The language is the language of paragraph 2.2 in any way ambiguous?
the language is not ambiguous,
Right,
but
thank you.
one has to divine the purpose of that language, and if the purpose is not achieved, what one has to one is looking for what the Secretary of State intended, and in my submission, it is proper to look at the overall, and I've made the submission, of course, my lady, the overall operation of policy, the history of 39E.
Got all of that,
Yes.
Mr. Judge. I'm so sorry. The gateway to looking at the purpose, as I understand the statement in paragraph 50, is ambiguity in the language of the rule, and you've just accepted that the language of the rules is not ambiguous.
I wouldn't say that the gateway to trying to define what the Secretary of State intended is ambiguity. The purpose
Right, okay. So you
of
don't
construing the
accept-
rules is to find what the Secretary of State
No,
intended.
I've got that. So I don't accept that ambiguity gateway to purpose. All right, that's very helpful.
Ambiguity is the gateway to looking at policy to provide an aid to construction, but not necessary in order to construe the rules as a coherent whole.
Thank you.
And if I could take the court to paragraph 58. Quoting from another decision of this court in Ali, confirming that an application made within 14 days is not in time, but the fact that such a person is permitted to make an application means that the Secretary of State will not refuse such an application on the ground that the person is in the UK in breach of immigration laws. And of course, I take the point that's been made repeatedly to me that that is not what has happened in this case. It's because of immigration bail. But the appellant's submission in response is that that itself is a consequence of the appellant being in breach of immigration laws. And if one gets in through the back door, that is still undermining the policy and express purpose of 39E. And Upsall also provides assistance at paragraph 11 with at paragraphs 11.1 and 11.2 the appropriate approach to construing the immigration rules.
There's a lot of law about that, isn't there? There's Marhad, Wang.
Yes,
lots of
and
authority
yes,
in
my
the
lady,
Supreme Court.
and this sort of neatly summarises it all. But the appellant would submit that ultimately these are statements of the Secretary of State's administrative policy, and the task is to construe what it was the Secretary of State intended at the time the rules were made. And that applies to 39E and its predecessor provisions, because those are provisions that are in question, and also to 2.2b. What did the Secretary of State intend? And if the court concludes that the Secretary of State intended that 2.2b would potentially undermine the operation of 39E, then of course, so be it.
There's a clue that the Secretary of State intended that 2.2b would I mean, I just don't understand this.
That is the practical consequence, my lady, inevitably.
Right.
As I've said, as one can see in the appellant's case, without any reason. There's nothing in her history or nothing that is pointed out by the Secretary of State that suggests that she should be a person that should be deprived of the benefit of 39E, as opposed to other people. And you have the categories that we've set out in the supplementary skeleton. My lady, there is the historical injustice point. I think I've addressed that as we've gone along. I don't think that, I don't know if,
I think you have, and we've got it.
and I know that the
it's
court has done a lot
expanded
of
in your-
reading. I don't want to go over ground that has already been considered unnecessarily.
No, I think we all are clear of what your argument
I'm very
is
grateful.
about.
Unless there is anything further that I can assist the court
Just
with.
give me one moment. Do you want- I was just consulting with my lord and my lady whether or not we wanted to hear any additional submissions from you over and above those that we've got on paper
Yes.
about, in the event that we grant permission, whether we should then hear a judicial review ourselves, or whether it should be remitted, as the Secretary of State would wish, to the Upper Tribunal. But subject to you wishing to add orally, I think we've got your detailed submissions in writing.
I'm
We
grateful.
can always come back to you
Yes.
and give you an opportunity of saying anything in reply if we need. Are you content if we take that approach?
I'm very content. I'm very grateful.
Excellent.
Melody.
Well, thank you very much indeed. Yes.
My ladies and my lord, given that you've helpfully indicated that you've read the skeleton items, I don't intend to repeat the submissions that you have in writing, and I'll just pick up on some of the points that my learned friend has made orally this
Thank
morning.
you. That would be very helpful.
Structure is, firstly, I'll address you on the question of whether the appellant was lawfully placed on bail in April 2023, and then I'll address you on the submission my learned friend developed that there is an inconsistency between Rule SW 2.2b and Rule 39e and the disregard of overstay.
Thank you.
So in respect of the question of the appellant lawfully being placed on bail, my first point, and it's an obvious one, is simply that it's now clear beyond doubt that the appellant challenges the decision to place the appellant on bail in April 2023. Of course, that was hopelessly out of time at the point that the judicial review was launched. Indeed, it seems to me, I wasn't in the oral permission hearing, but it seems to me that there was no application to extend time in the Upper Tribunal in respect of that decision. But that being aside, you've obviously heard extensive argument on the point, and I'm certainly going to make arguments on the substance of that decision. The appellant was lawfully placed on bail. She was liable to detention pursuant to the power set out in Schedule 10 of the Immigration Act of 2016, when that is read with Section 62 of the Nationality and Immigration Asylum Act of 2002. That was because she may be detained pending removal from the UK. The reason why she may be detained is that she requires leave to remain in the UK but didn't have it from that point on the 28th of April. And you've been taken to the decision where that where the refusal was made, and that refusal, as you recall, said you will now be put on bail, and then there was a bail decision that was served at the same time. A point raised in the written submissions and touched on by my learned friend Mr. Jafferty today was that the appellant only became liable for removal the following day, i.e. the 29th of April 2023, after the refusal and certification of the decision on the 28th of April 2023. The grant of bail, as you recall, is dated the 28th of April of 2023. That point was simply not developed by my learned friend in the written submissions or in my submission orally. There were no authorities, for instance, that were referred to support the proposition that you have leave to remain until midnight of the day in which you are served with a refusal, and you become liable to detention at 1 minute past midnight the following day. It is simply an assertion that is made, and it goes against the facts in this case, which are that she was told in the letter of refusal, you are granted bail from the date of this decision. My learned friend orally did develop the point with reference to the chronology in my skeleton argument, which is on page 4 of my skeleton argument, pointing to the fact that on the 28th of April, as I've said, the refusal occurred and the grant of bail was made, and then, in fact, the application for leave to remain as a skilled worker was made on the 12th of May, and my learned friend made the point that that's in fact 15 days after, and she wasn't refused for being an overstayer. So it must be that the Secretary of State considered that the time started from the 29th of April. That doesn't follow. It may in fact be the case that the Secretary of State made a mistake and calculated the dates wrongly. So it is, in my submission, equally possible that the Secretary of State could have refused this appellant on the basis of SW2 2.2a, she was overstaying and the disregard doesn't apply because it was for more than 14 days, and B, because she was on bail. But to the appellant's benefit, the overstaying issue was not taken into account, either by accident or deliberately. It doesn't matter, and it's not necessary for this court to determine. The focus was on bail. So in summary on that point, you cannot, in my submission, conclude simply on the basis of that date issue that the Secretary of State accepts that leave to remain runs until midnight on the day and bail starts the following day. My next point relates to the submissions my own friend developed this morning about the concept of bail being related to detention. And the suggestion, at least as I understood the submissions, that bail was unlawful or invalid because the Secretary of State failed to take into account the factors that are to be taken into account in the policies which the Secretary of State takes into account when considering whether to detain them. And perhaps I will at this point invite you to go to the authorities bundle and page 706, which is tab 28. This, as you'll recall, was the document that you were taken to mostly, and then at page 713, under the heading Deciding Liability to Removal and Whether It Is Proportionate to Commence Action, there are a series at the top of bullet points that are developed over the following pages about gathering and assessing information, about risk assessments, special conditions, and so on and so forth. The simple point in response is that these are all factors that may be relevant to the question of lawful detention and may be relevant to the question of removal. But they are not relevant to the critical question of whether the appellant was liable to detention. And confirmation of that can be seen if you go forward in that document to page 729. And the bottom of that page, there's the heading Evidence of Overstaying, and the guidance records, person who overstays their limited permission is liable to administrative removal under Section 10 of the 1999 Act. There's no suggestion that this appellant was not liable to removal, and therefore it follows in my submission that she was lawfully put on immigration bail, even though the Secretary of State cannot point to these particular factors being taken into account because they're relevant to the next stage, to removal. That point raises the cases that my Lady Justice Laing raised yesterday of Katie. I don't think it's necessary in the circumstances, given my learned friend's concession, that the critical question is liable to detention, to go into those cases. Suffice it to say that they confirm that the question of whether someone is lawfully put on immigration bail is whether they are liable to detention. It does not mean whether they are liable to lawful detention. And as my learned friend has accepted that that's the question, and as he has also accepted that she was liable to detention, it follows that the policies that my learned friend took you to that relate to all these other factors are simply not engaged on the facts of this case. I now go to perhaps the more substantial element of my learned friend's submissions that are my second point, the question of incompatibility or inconsistency between either the rule itself, SW 2.2b, or the application of SW 2.2b in this case, and on the other hand, the disregard of overstaying under Rule 39E. Secretary of State's decision to refuse the skilled worker application follows inevitably, and followed inevitably in this case, from the fact that she was on bail. The suggestion in my submission that the placing of an applicant on bail means that there is an inconsistency is wrong. Firstly, the question of interpretation. Now, we say, as set out in our respective skeleton arguments, the question of interpreting the immigration rules is settled. I don't think I need to take you to those authorities, Wang and Mahad, which are in the authorities bundle. But the question is what the Secretary of State intended the rules to be, and that intention is to be discerned objectively from the language used. So the language used in this case, we say, is clear. It is SW 2.2b says if you are on bail, you are not suitable. It is only necessary to look at the intention behind the Secretary of State's passing of the immigration rules and the aids to construction if the construction of the rule itself is ambiguous. you may find, and I invite you to find it to be unambiguous. But if you do go on to consider that it could be ambiguous or could potentially be ambiguous, and you wish to consider intention, as in the Secretary of State's intention when she passed Rule 39E or its predecessor and SW 2.2b, then it doesn't follow that there is some inherent contradiction between them, or that the way the Secretary of State has applied them means they are inherently means that they are contradictory in this case. If I could invite you to go to Explanatory Memorandum 194, which is behind tab 24 in the Authorities Bundle, page 579. And you'll recall that my learned friend took you to the purpose of the instrument heading behind paragraph 2, and then the 5th bullet point down being to introduce a consistent approach to dealing with applications for leave to remain from migrants whose previous leave has expired. And you'll recall the submissions made repeatedly that this was a flagship policy, that consistency was the key word in my learned friend's submissions. It is important to understand that paragraph in its full context. At that time, there was not a consistent approach to disregarding overstaying. It was not the case that this predecessor to Rule 39E brought in the concept of disregarding overstaying for the first time. So, for instance, at the time this was passed, overstayers were excluded from applications under family routes, but they weren't from routes under points-based systems. So that is the context in which the word consistent should be interpreted. Consistent, in my submission, does not mean everyone who overstays, no matter what else they do, will be entitled to apply for leave to remain without that overstaying being held against them if they do so within 14 days. What consistent means here is that the concept of overstaying should be applied consistently, whereas before it was not applied consistently. So put another way, what is said in paragraph bullet point 5 is merely a statement that there is to be a consistent approach to overstayers. Consistent treatment of overstayers does not mean that every overstayer will be found suitable to make an application for leave to remain thereafter. Secondly, again, if you consider the rule to be ambiguous, and you do wish to consider the Secretary of State's intention, the Secretary of State's intention when passing skilled worker paragraph 2.2b in 2020 does not undermine or contradict what the Secretary of State intended when the predecessor to Rule 39E was passed. If I can invite you to go to the supplementary bundle, where the explanatory memorandum behind Rule SW 2.2 appears at page 155.
Sorry, give us that thing.
Yes, 155 of the supplementary bundle. So this is the explanatory memorandum to HC 813, the statement of changes from 2020, and of course this follows the memoranda I took you to before, which was from 2012. The purpose of the instrument is to amend the immigration rules that are used to regulate people's entry to and stay in the United Kingdom. They deliver a future points-based immigration system, a further step in realising commitment to simplifying the rules, implementing the recommendations of the Law Commission to ensure we provide greater clarity to migrants and all users of the rules. Critically, though, 2.2 summarises the main changes, and the third paragraph from the bottom refers to the skilled worker route, being a new points-based route for those who wish to come to the UK. And then the following page, which is page 156, behind paragraph 2.4, we have these words, which are significant. We have also revised and simplified the rules on the exercise of the powers to refuse or cancel permission on suitability grounds. That is confirmation that the Secretary of State, when she introduced Rule SW, skilled worker, intended to revise the powers to refuse permission on suitability grounds. SW 2.2, as you'll recall, is a suitability ground. SW 2.2b was therefore an example of a revision of the Secretary of State's powers to cancel or refuse permission on suitability grounds, in this case, because someone is on bail. So that is why in SW 2.2, the word or is used rather than the conjunctive and, i.e. someone is unsuitable if they're in breach of immigration laws, except when 39E applies, or if they are on immigration bail. They do not have to be both an overstayer and on bail. So my summary on that point is, again, to the extent you feel there may be ambiguity and you do wish to consider intention, the intention is there in black and white. It is to revise the decision maker's powers to refuse permission on suitability grounds, and SW 2.2b is a plain and straightforward example of a new suitability ground, a revised suitability ground being implemented. My third point on this issue of tension between SW 2.2 and 39E relates to my learned friend's submissions this morning and on paper about the fact that some overstayers will be treated differently. You'll recall his paragraph 21 of his skeleton argument and the 4 categories of persons that he says will be of overstayers that will be treated differently. And you'll recall he says, well, the appellant in this case falls under his category 2, which is someone who's had their application refused with no right of administrative review. They apply for permission to stay within 14 days. Well, they may still be on bail at that point, so they don't enjoy the disregard from 39E. The first point is that the Secretary of State accepts that there may be some overstayers who are not placed on bail and others who are. And it may be that the appellant, because she applied after her application had been refused and certified, and therefore had no right of appeal, and was immediately put on bail, is in a worse position than someone who applied and was simply refused and not certified, and so therefore had a right of appeal. That doesn't mean that there is a defect in the way SW 2.2 has been drafted or applied by the Secretary of State. That is simply a feature of the rule, that some people on bail will be, some people will be put on bail and others may not be.
And it would be mad to put someone on bail if they've got a right of appeal, which they haven't just exercised.
Yes.
And their appeal rights are not exhausted.
Yes.
Because they're not removable.
Indeed. Secondly, though, the point about the alleged inconsistency between these four categories of overstayers is that that misunderstands the point of Rule 39E. 39E, in my submission, simply confirms that when considering suitability for permission to stay, whether someone was overstaying is to be treated in the same consistent way. It doesn't mean that overstaying is the only factor when considering suitability. An additional factor, as I've made clear earlier, is the question of whether someone is on bail. They are parallel and overlapping provisions, and applicants must satisfy both to be suitable. The simple fact is, though, in respect of all four of these potential categories of overstayers, that at the point at which they do not have permission to stay, they either don't have a right of appeal or review, or the right of appeal or review has expired or been refused. From that point on, all four of these categories of persons are liable to detention. And from the moment they're liable to detention, they're at risk of being put on immigration bail. I don't think it particularly assists to go through examples of all these, but taking the first one alone, this is the category: a person that remains beyond the expiry of his permission to stay and then applies for permission to stay within 14 days. And my own friend says, well, that's the most culpable type of person, and it's perverse that that type of person is probably going to benefit from 39E, whereas a person like the appellant who applied and is put on bail is not going to benefit. But that simply isn't necessarily true. If after a person's permission to stay has expired and they are encountered working by the Home Office, they may very well be put on bail. And that is encountered within 14 days. So they too may not enjoy the 39E disregard. And similar would occur with the other two categories, category 3 and 4, people essentially whose administrative reviews or rights of appeal have either not been exercised or have expired. Again, they are liable to being placed on bail from the point that those things come to an end. And so they are in fact treated consistently, because from the point that they are liable to removal, they may be placed on bail, and from that point they will be caught by SW 2.2b and it's worth making the point in my submission that in that sense, or at least in one sense, the appellant is the author of her own misfortune. As I set out in my skeleton argument, the reason why she has no right of appeal, which may put her into category 3 or category 4, was because she made what I described as a hopeless application, a human rights application, the previous year, which was refused and was certified because it was so hopeless. Had instead she applied, even some days after her previous leave had expired, for a skilled worker place at that point, then she would have enjoyed the benefits of the 39E disregard. And my final point on arbitrariness or alleged inconsistency is that the court should be aware that this application of a suitability requirement not to be on bail does not just apply to SW 2. To the skilled worker route through SW 2.2b. In fact, it applies to numerous other provisions in the rules, Appendix Long Residence, Appendix Ministers of Religion, International Sportsperson, etc. So this is not an example of a rule that, if my learned friend is right, you can simply reword and everything else would trundle along happily. In fact, anything that the appellant suggests in terms of remedying the alleged inconsistency would have significant knock-on impacts on other provisions in the rules. My ladies, my lord, I think those are all my submissions. If I could just turn my back to see if there's anyone else.
The point that I put to Mr. Jafferty about the oddity that a person who is detained seems to get the benefit of 39E. Do you have anything in response to that?
Yes, not perhaps as complete a response as I may, as you would like, but my understanding is that someone who is detained, firstly, is probably unlikely to be applying for a skilled worker through the skilled worker route, but would be refused on general grounds.
Because they'd be detained for reasons which would equally apply under the general grounds. Is that...
Because they're in breach of immigration law. So if they're detained because they've been
in breach of immigration law, that's the starting point. But they have to be liable to be detained before they can be put on immigration bail, and they have to be liable to be detained because they're in breach of immigration law.
They are liable to detention because they no longer have leave to remain. So they're not necessarily in breach of immigration law, it's simply that they don't have leave to remain at that point. Whereas someone who has been detained would be in breach of immigration law by principally working. And so that is why they wouldn't benefit from the
But surely you are in breach of immigration law if you require leave and don't have it. You're here unlawfully.
Yes, I see the point. I'm the reason why I raised the answer that I did to my lord was those are my instructions, but yes. I can see the limitation that my lady
you
makes.
Could say it doesn't matter. It doesn't impinge on the rationality, lawfulness, or coherence of the bail exception. It just means that there's something else that's been left out.
Yeah.
At worst. But it did seem a bit puzzling.
Yes.
And your explanation may make sense that that person is almost certainly going to lose on general grounds for reasons that will be related to the purpose of detaining them rather than putting them on bail.
Yes, I think that's right. At worst, that is, a perhaps unjustified benefit that goes to a small category of people. But
they'd be likely to fall within A.
Yes.
I mean, even as well as the general grounds.
Indeed, yes. If I'm wrong about the general grounds, then the worst that can be said about that is that yes, there may be some people who benefit in that way, but I don't think I can necessarily.
It's a sort of disparity argument in a way, isn't it?
It is not the disparity argument my learned friend has made. Another one, but
yeah.
Yes, I think you understand this. Unless there's anything else I can assist.
No, just simply you maintain your position that in the event that permission was granted, the matter should be remitted to the Upper Tribunal.
Indeed, I do. Yes.
Thank you very much. Anything you want to add about that?
No, you have my written submissions.
Thank you very much indeed. Anything in reply?
Really, I'm grateful. If I could just start at the end and the discussion on breach of immigration laws. But I take my ladies and my lord to page 453 of the authorities bundle. You will see the definition of breach of immigration laws does, as my lady Elisabeth Laing said, include a person who's an overstayer, so that is within the definition. The point at which a person becomes an overstayer is a point that's been addressed in the skeleton arguments, it is a point that is important because it dictates both the point at which 39E no longer applies. It also dictates the point at which a person might be acting unlawfully in terms of working in breach. It dictates the point at which an employer might be employing somebody in breach. And it dictates all of the time limits that flow from the decision, such as time limits for administrative review, time limits for exercising rights of appeal. All of the legislation and the provisions of the rules refer to days, as does 39E.
What about section 3C? Because wasn't this section 3C leave?
Yes, my lady. If I think we have section 3C.
Section
in the
3C in the
authorities
bundle?
unfortunately, it is not. But I think we have
Because
it.
I had a quick look because I wanted to check, and it's not in the bundle for some obscure reason.
It is referred, I think, to in Abza. So page 160 of the authorities bundle, paragraph 10.
Because I noticed when we were shown some passage in one or other of the bits of guidance, that the guidance suggests that section 3C leave expires at the point when the application is refused.
My lady, there is one passage in the guidance that I have read as well that does suggest that.
Yeah.
The appellant would say that that is not correct. When one looks at section 3C, when one looks at, and I don't think we have these provisions, they can be provided after the hearing if it is something that...
Well, I think we do need to have section 3C, please.
It's at paragraph 10, page 160.
See that its operation depends upon time limits for appealing, for administrative review, for the expiry of onward rights of appeal. One can also see if one, and unfortunately we don't have these rules and the order in the authorities bundle, but if one looks at the 2000 order, Immigration Leave to Enter and Remain Order 2000, which makes provision for the service of notices where there is a right of appeal. That refers to time limits in terms of days. If one looks at Appendix SN of the Immigration Rules, which refers to the service of notices where there is a right to administrative review and the expiry of the time limit for making an application for administrative review, it refers to numbers of days. 39E refers to numbers of days.
If we just go back to 3C2.
Yes.
3C1 tells you when section 3C applies. 2. The leave is extended by virtue of this section during any period when A. The application for variation is neither decided nor withdrawn. So once the application for variation is decided, the leave is no longer extended.
Yes, if there's no right of appeal.
Yes, it doesn't say anything about days or...
No, but if one reads on, one then has an appeal under section 82(1) could be brought. So that would. But
we're not concerned with any of that because there's none of those things applied here. So what we're just concerned with when the 3C leave in this case came to an end.
Yes, but in order to interpret that, my lady, one has to consider the effect of 3C, because if there was a right of appeal, one would have to calculate the date on which that right of appeal expired.
And it is that subsection 6 gives the Secretary of State power to make regulations determining when an application is decided for the purpose of that section.
And my lady, we have, yes, my lord, we have the 2000 order, we have Appendix SN, we have the notices regulations as well, I think, which might well apply. But the point is, and of course we can provide these provisions.
Well, I think we'll have to look at them.
What we're concerned with is regulations made in the exercise of that power.
Yes.
Not anything else.
Yes.
There are all sorts of other statements about what the right answer is, but they're not decisive because they're not
regulations.
Decisive if they're the regulations made under that power, aren't they?
My lord, yes. But the point is that one can only apply section 3C if one knows. In the appellant's case, It's just one knows when the application was refused.
Yes,
therefore
and
when
that's why
Section
we need to
3C
see the regulations to which my lord has just referred were
Yes.
made under Section 3C6. So please, after the hearing, could you make sure that we are sent those regulations?
Yes.
Thank you.
And so if there is a right of appeal, one has to calculate the point at which the time limit for appealing expires, because that is the point at which Section 3C leave would come to an end. So if, these often notices now are served by email. I think this notice was served by email. If the email is received at 11 a.m. in the morning, does the time limit expire at 11 a.m. 14 days later?
Well, it doesn't matter because we're not concerned with that. All we're concerned with is when the decision is treated as having been made, and that's why we need to see the regulations.
But my lady, that is important in assessing that, because one has to read, if leave expires where there's no right of appeal at the point of service, that must be the same for any other decision where there is a right of appeal. And so when does the 14 days expire? One has to consider that. And the appellant's point is that everything is calculated in days. And the Secretary of State herself, in this case, has calculated the 14 days as a number of days, with the first day being the day after the decision was served. And one has to contrast that with the way in which a particular category of a decision works, which is a decision to cancel permission with immediate effect. And we have that is referred to in the guidance that we have in the authorities bundle. If I could take the court to page 890, which is in tab 32. You will see that in cases where the person is in breach of the rules because they've been working in breach of their permission or they've used deception, permission is cancelled in appropriate circumstances with immediate effect. And there must be a difference between ordinary cancellation or ordinary leave expiring and those cases where...
We're speculating, and we don't need to speculate because the answer is likely to be in the regulations, isn't it?
My lady, I don't think the answer to the timing is in the regulations, just as I don't think the answer to the timing is in any other case law. I don't think it's a point that's arisen before, in that it is asserted by the Secretary of State that Section 3C leave comes to an end at the point of service as opposed to at the end of the day on which the decision is served. And that is why there is no case law that is before the court.
This isn't within your grounds of appeal, though. This isn't what this appeal is about.
One of the points...
Yes, also to...
One of the points that was made in applying for permission to appeal was that the grant of immigration bail on the same day was unlawful because she wasn't an overseer on that day. That's something that has been raised from the outset. It is something that was addressed in the skeleton when applying for permission.
Made in the Upper Tribunal application for judicial review.
I'm sorry, my lady?
Was that point made in the application for judicial review in the Upper Tribunal?
I'm pretty sure that it was.
Well, we can check, it doesn't matter.
Yes. If I take my ladies and my lord to page 15 of the core bundle where the grounds of appeal are set out,
I have them.
one can see in 3.2, the second ground of appeal, it's put in two ways: whether there had been a power to place her on immigration bail at that time, and or whether any such power had been exercised in accordance with the respondent's own policy.
Now, we are in reply.
Yes.
Is there anything else you wish to?
In terms of consistency, we still do not have an explanation for the Secretary of State as to why there is inconsistency in this case. And what the unsuitability is, apart from the fact that the Secretary of State decided, without giving any reason still, to place the appellant on immigration bail. As far as the supplementary bundle at 156, my learned friend referred to paragraph 2.4. Of course, the intention, if that is, and that is the only thing that the Secretary of State is able to point to, which tells us what the Secretary of State's intent was when bringing into force SW 2.2b, there is nothing clear in that at all. It's just a broad intention to simplify the rules on the exercise of powers to refuse or cancel permission on suitability grounds. There is still a tension within the suitability criteria, because the suitability criteria includes expressly at 2.2 39E, and therefore that tension still exists, even if one takes into account and assumes that this was all part of an exercise to simplify it. Well, it hasn't simplified it. In fact, it's made it more complicated, because one doesn't now clearly know which overstayers within the first 14 days are or are not going to be suitable. One has the exercise of discretion by the Secretary of State as to whether or not to grant bail. The Secretary of State accepts that that might well be inconsistent. It might well be that some benefit, some don't, but we don't have any policy reason for it. We don't have any guidance on it. We have no explanation for it in the appellant's particular circumstances. In relation to those that have appeal rights, there is no power to place such persons on immigration bail until they become overstayers. And they will only become overstayers once those appeal rights have been exhausted.
We're aware of that.
I thought that there was an exchange during my own friend's submissions which suggested that they were not.
Well, it's my fault if I didn't make that clear. Of course, I'm aware that you can't put somebody on immigration bail if they have a right of appeal which they haven't exercised. And they're not appeal rights exhausted because you can't remove somebody if they have appeal rights they haven't yet exercised during the period during which they could appeal.
As far as the submission that the appellant was the author of her own misfortune is concerned, the appellant has made submissions in the supplementary skeleton argument that the assertion in the respondent skeleton that this was a spurious application, a hopeless application, and an application based on
certified, and there was no challenge to the certification.
That doesn't mean that the application itself was spurious and hopeless. One has to look at the application.
I see.
The application is at page 112 of the supplementary bundle. It doesn't make any reference to Article 3. At 114 of the bundle, the appellant, who was not represented at the time, says, and this has been set out in the supplementary skeleton, my child cannot leave the UK as he does not have any passport or valid ID for travel. We're applying to stay in the UK because my medical condition prevents us from travelling to India. I recently gave birth, suffering from postpartum depression. My child also does not have passport or valid ID to travel. I'm not able to travel. I'm not able to fly at this time. Been advised not to travel for at least 6 months. I hope you understand my situation and grant me 6 months leave to remain based on my medical health. Now, it might well be that the Secretary of State decided to consider that under Article 3 because medical reasons had been raised, and it might be the Secretary of State properly decided more than 6 months down the line that any appeal at that point would be hopeless. But that doesn't mean that this was a spurious application, just a bridging application, or an application without any merit at the time that it was made. And of course, the Secretary of State accepts a person that simply overstays, and the Secretary of State's position is that the primary policy objective of the Secretary of State is that persons should apply before their leave expires. The Secretary of State accepts that the way in which this practice is likely to operate is that persons who don't do that might well be in the best position to benefit from paragraph 39.
We've heard your submissions about that.
My lady, I mean, there was nothing else that I wanted to add. I just wanted to, obviously, full submissions have been set out in the skeleton arguments, and just make reference again to the grounds of appeal,
Yes.
which are all pursued.
Yes, of course. Thank you for clarifying.
I'm very
that.
grateful.
Thank you.
I'm acutely conscious of the time,
No,
but
well-
my lord asked a question which I didn't have an answer to, and I now do, thanks to those who sit behind me. The case of someone in detention would be covered by, and I can simply quote the rule number, Rule 9.8.3, which is an application for permission to stay may be refused where a person has previously failed to comply with the conditions of their permission, unless permission has been granted in the knowledge of the previous breach. And that, we say, would engage SW 2.1, which is that a person must not fall for refusal under Part 9. So I hope that answers that
Thank
question.
you for that, and thank you for those behind you that burrowed around to find the rule. Thank you. Very well. Well, thank you all very much indeed. You won't be surprised that we're going to reserve our judgments. They'll be sent through to you in draft in the normal way for typographical and other infelicities, but not as an opportunity to re-argue the case, which we've got orally and in the detailed written submissions. The embargo applies, please, so please note that it remains under embargo until we hand down electronically our final judgments. We hope you'll be able to agree an order at the end of the day. If there's any other further matters on which you're unable to agree, we'll deal with those in writing. So, thank you all very much indeed.
What rise of voting?
Ballet was that. Yes, chair.
It's almost like I'm getting into it. Normally the gov Wi-Fi is really stable, but
Same.
it kept sort of switching on and off.
I think we're better.
It's connected to the hotspot.
I'll say how.
Yeah, I tried to do that and that didn't work either, so yeah, but eventually, anyway, managed to.